Chapter 17, Learning Objective 6, Part 2, and then we're going to go through the conclusion of the chapter as well. Now, the grantor of a trust is the creator of the trust. It can also be referred to as a settler or the donor. But the grantor is the most commonly used name. Trustee is the person who's in charge with carrying out the trust for the benefit of the grantor and their heirs. Trustee is very much like the executor of an estate. Corpus are the assets placed into the trust. The beneficiary is the person whose benefit the trust, or for whose benefit the trust was created. The remainder beneficiaries are the person or persons that just receive the trust asset at the termination of the trust. It could be the same person, they could be somebody different. A living trust is a trust that takes effect while the grantor is still alive. A revocable living trust, grantor maintains the right to change the trust terms or cancel it at any time for any reason during his or her lifetime. Irrevocable living trust, a trust arrangement which the grantor permanently gives up ownership and right to control the property, to change the beneficiaries, to change the trustees, etc. Testamentary trusts become effective upon death of the grantor according to the terms of the grantor's will or revocable living trust. Federal state tax is assessed against a deceased person's estate before the property is transferred to heirs assigned according to terms of will, or state intestacy laws. We talked about intestate previously. The basic exclusion amount, the value of assets that may be transferred to heirs without incurring estate tax, it's very large. The amount is $5.34 million, and this may have changed because these are 2014 numbers. But for the most part, most of us don't have $5 million. So as a result, very few people are subject to federal estate tax. There's a gift tax exclusion as well, $14,000 per year. Again, that number changes. I'm not sure if it's still $14,000 or not, but and also the gift tax can also assuming you were wealthy or you had the means to do so, you would be allowed to give your say your child or your grandchild $14,000 per year, and your spouse would be able to do so as well. The gift tax applies to the giver, not the receiver. So the receiver would never be subject to tax, but the giver could potentially have to pay gift tax if they gave an amount greater than $14,000 per year. Marital deduction allows the state to pass on to an unlimited amount of assets to a surviving spouse free of estate taxes. 19 states have a estate tax that is coupled with a federal estate tax, so it doesn't impact the amount of tax paid. It just impacts to which state it might, to whether it goes to a state or to the federal government. The inheritance tax is based on how much beneficiaries get and their right to receive it. Only 8 states have this tax. Texas does not. Okay, concept check 17.6. What is probate? And give 3 examples of how people transfer assets by contract to avoid probate. Probate courts supervise the distribution of assets of the deceased. Probate can be avoided by beneficiary designation, payable at death contract designation, and joint ownership with rights of survivorship. What topics go into a properly drafted will? Property included, listing of heirs, appointment of the executor, selection of guardian for minors, selection of someone to manage assets inherited by minors. This could be the guardian or someone else. What is the likelihood of the average person paying estate or inheritance taxes? Very low, because taxes are usually only apply to very wealthy individuals. We saw previously that there was a $5.4 million exception. Okay, so worst financial blunders you can make a retirement planning. Wait until your 30s or worse, your 40s to start savings for retirement. Forget to update the forms that contractually award assets upon your death, like life insurance, retirement, checking account, so forth. For example, if you were to go through a divorce, you could potentially, without thinking about it, leave your ex-spouse's name on your down as the beneficiary for one of your accounts. If that were the case, your ex would receive your assets. Number 3, invest in mutual funds that charge high expenses. This also applies to hiring investment advisors that charge very high fees. Mutual fund fees are, like I said previously, around 1% or can be up to 1% or even more. Investment managers typically charge 2%, even more than that. So do it now. Obtain your Social Security statement from www.ssa.gov/my account. Calculate your retirement savings goal at both 60 and 67 based on your projected income following graduation. Setting up as much property as possible as non-probate. Write your will for the remainder of your assets.